refuge in director of research. I'm sure he's behind everything. That's very important. He did a lot of work, excellent work on the constitutional reforms. He was the executive secretary at that time. Unfortunately, for all the work that they did, up to, I think, from 2011, when the report was finally issued, there has been no political will to be able to move beyond the report and move into execution, which is very unfortunate. So, in a sense, what I'm committing through the GTP is that we'll make sure that we put in place an implementation framework that would ensure that the reforms are actually implemented. So that is basically the commitment, and that is why I've also taken trouble to limit and reduce the scope of the reforms, because as I'm sure Prof. himself would agree, and they didn't come from the commission as such, because they were consolidating the views of all Ghanaians. The number of proposals that were put forward through this review exercise threw up so many reforms that people started questioning whether it was going to be possible to amend the constitution based on all these proposals, or in actual fact, you should end up rewriting the whole constitution. Because in law, once you end up having a substantial revision of the provisions in any legislative document, then obviously you might as well introduce new legislation. So that has always been part of the problem. The other problem had been consolidating and having consensus on some of these critical reform proposals. But I don't need to wait to become president. I'm saying that I've looked at all the proposals. These, for me, are the most critical ones, and I prefer to commit my presidency to ensure that we move forward with these reforms. So, on that basis, I think the School of Law wants to know to the extent that the second chamber can be operationalized in terms of the procedures and mechanisms to avoid overlaps also between what we call the first chamber or main parliament now. That I think that we didn't get into the details because at this stage it is the principle for establishing the second chamber. But when we come into the second volume, which I was talking about, which is the implementation modalities, that is when we flesh out all the elements of second chamber. But at least it is clear that we've identified the key responsibilities of the second chamber, which includes making sure that there is oversight and control over executive action, which currently is not optimal, looking at the constitution as it stands. So, Madam, implementation modalities in the scheme for that will spell out all the. But in terms of overlap, the main chamber will still have responsibility for legislation, but a significant part of what the second chamber will do is transferring the responsibility of the council as they are now into the second chamber. But the nature of the second chamber would give it more power. Because if, for example, they have the authority to nominate or make recommendations for the appointment of the Electoral Commission, which is one of the ICBs, then it limits government's capacity to be able to determine and control the position of the Electoral Commission. Now, number two was the appointment of heads of ICBs and making sure that we don't politicize the appointment. But that is exactly the reason why we are moving the appointment of the heads of these ICBs in the second chamber. Because when you say politicizing, then it is because in the current dispensation, it is the executive that does the appointment, albeit in consultation with the Council of State. So once you are moving that responsibility of appointment from the politicians, as it were, then you are depoliticizing it. Because in the second chamber, the kinds of characters there, they belong to different parties. Anyway, they belong to different parties. And they have, based on their representation of stakeholder groups, they have a different mindset as to what they are looking for. So that is the basis for depoliticization. Number 3 is keeps traditional authorities becoming co-trustees of mineral resources. It's one of these things that this this morning, afternoon, I've been making reference to. We have no choice because you invest the rights of all mineral resources in the president in trust for the people of Ghana. On the surface of it, like you have no choice. That's what you've got to do. But the fact that you can sit on your land, in your house, on your land that you have built, and meanwhile, without your knowledge, the Minerals Commission has already issued the minerals concession for that piece of land that your house is built on. Does it make sense? You have bought a piece of land. You have built your house. Because Minerals Commission has information that there's gold under the land, then they issue concession for somebody who has nothing to do with your land. They issue a concession for them to come and prospect and mine, and by extension destroy not only your house. So you are losing not only your right to the land, you are losing your house. And the accruing benefits of the gold that has been basically bestowed to you by your family, you have no. And meanwhile, the Minerals Commission, an official is sitting there, he has given that concession to Udike through fraudulent means, for example. So you benefiting from that as against the owner himself, at least being part of it, which is better. Being part of it, So that is what we mean by having traditional authorities, again, also on behalf of their own people. This thing about president having a co-trustee or trustee on behalf of the people, it is too ambiguous that he is trustee for all mineral resources. So, but if the traditional authorities are co-trustees, because the land belongs to the schools, and they can give you a lease, an individual. So if you want to deny the chief authority to also have a say in who gets the concession to the land, then you're also denying the people, in a very humble opinion. So that's why, but in terms of how this will be operationalized, avoid conflict, as you rightly pointed out, between national interest and then, let's say, the interest of the local authority, all those would be reflected in the implementation modality. But Ghanaians first have to accept the principle. We want mineral rights to be vested only in the president, and he delegates that right and responsibility to Minerals Commission, and Minerals Commission decides what they want to do. Is that the kind of regime that we want? At least if the chiefs are co-trustees, and he has agreed that your land and your house will be, assigned to another person, then at least you can go to the chief and contest it. How can you go to the president to challenge him? for allowing land in your house now to be encumbered through the grant of license by a public servant. Public servant. How do you know how they have granted these licenses? They don't. Then I think to terminus with that, you raise this issue of the management of lands in general. So it's all part of new regulations, legislation that we will be proposing in terms of management of lands. Then election of MMDCs. And I'm happy that we are on the same home page, that your department, your school, the Social Reform Commission, proposing the same, I think, principle of election of MMDCs. But I'm also very happy that you are aligning this to the whole reform agenda for local governance and decentralization. So it's not just a question of electing MMDC, which is what everybody is talking about. It's a small part of the reforms that need within this whole decentralized regime. And we have some proposals on the local government decentralization in the GT, apart from the reforms. So I'm saying that if you read all the different components of the GTP, you find that we agree with your position and we've made proposals for deepening local government. For example, district assemblies and the role that they play. We have to interrogate it. Are they playing an effective role? And to what extent do they affect the management and control and administration of towns and villages? If you go to more matured economies, the real action is at the local council level. Is that not the case? Local councillors and then, but the district assembly concept, it has its merits. But I think it is time for us to really review that within the context of the larger question of local administration or decentralization. We talked about the office of the Attorney General, and I want to clarify our proposal to amend Article 88, 3 and 4 in respect of the prosecutorial authority of the Attorney General is only in respect of corruption-related matters. As it exists now, there's a multiplicity of institutions and by extension, legislation that purports to address the issue of corruption. Special prosecutor is supposed to be addressing the issue of corruption. Siraj says they are addressing corruption. Yoko says they are addressing corruption. Police CID makes a claim to the same effect. And so there is no harmonization of provisions, legal provisions in respect of addressing corruption. In fact, the definition of corruption, and that's why you realize that recently there was a conflict between the Special Prosecutor Office and the Yoko. So our proposal is that let us distill all the corruption-related provisions in existing legislation, scattered, and consolidate those corruption-related provisions into an omnibus corruption legislation, and then appoint an overlord with the appointment of a czar. It's in the literature, the czar means corruption overlord, so that there can be a single entry point in terms of dealing with corruption. But it does not affect the prosecutorial authority of the Attorney General for other criminal offenses. And that's the distinction I wanted us to make. Last but not the least, is the jurisdiction of the SAR. I think that's basically that's all. Yes. Now, I think there's been some worry in the CSO community about the implementation modalities from the point of view. Yes, we made nice proposals as sequential government in power, ARC. Now, so yes, we agree with the proposal, but how are you going to, what is the roadmap? What are the steps to ensure that this time the reforms would actually be implemented? Mr. Yao Buabin, he, in his previous life, has been part of the CSO community. So I'll ask him to give you just a brief sense of the modalities that we are proposing. So, yeah, but thank you very much.